Today I want to take you inside a tense moment from the Senate Judiciary Committee where Senator John Kennedy pressed a judicial nominee on one of the most sensitive issues in American law: religion, government, and constitutional rights. The questions were sharp, the answers careful, and the stakes couldn't be higher. Let me walk you through what happened. Senator Kennedy began by asking a fundamental question. Where does government draw the line when it comes to burdening religious beliefs?
I want to follow up a little bit about government and religion. What do you think the state of the law is in terms of U.S. Supreme Court jurisprudence on the extent to which, or how one draws the line with respect to which, government can or cannot burden my religious beliefs? I mean, I think as a general proposition, I can't reasonably expect government to promote my religious beliefs, but government shouldn't unduly burden my religious beliefs. That's the easy part. How do you apply that?
Well, I have to follow Supreme Court precedent. There's a lot of Supreme Court precedent in that area. I'd have to look to that first and foremost and follow it. And
what does the precedent tell us in terms of how one should make that sometimes subtle distinction?
I explained that government should never unduly burden someone's faith, even though it can't be expected to promote it either. That sounds simple on paper, but applying it is far from easy.
Well, precedent tells us, as you indicated, that the government can make no law that would establish or constitute the establishment of a religion. With respect to the free exercise of religion, the core right to worship, of course, is protected. To worship in the church of our choice, and that bubble sort of expands as we leave the church and exercise our religious beliefs in other areas. And so and when it starts to get into the area where perhaps it's in conflict with someone else's right, then that's where some of the tension comes in.
Supreme Court precedent becomes the compass, and that's where the real debate starts. Kennedy didn't stop there. He gave examples that tested the limits of religious freedom. One scenario involved a parent refusing medical care for a sick child because of religious beliefs.
Well, under Supreme Court precedent, let's say for example, and I don't know the answer to this, I'm not trying to trick you. If my religion prohibits me from having any interaction, let's say with the healthcare delivery system, and my son is very sick. It's clear that with proper medical care he would be saved. He's a minor, let's say. And I say, look, leave my son alone. God will heal him. Should the state be able to come in and say, hey, we're not saying you're wrong, but let's use belt and suspenders. Let's depend on God and a doctor.
Well, Senator, I want to be careful. I think there is some debate out there about this kind of issue, and to the extent it may get into political questions or possibly the subject of something that could become a legal case, I probably have to be careful about answering that question.
Another revolved around public accommodations, whether someone could deny service to people based on race if their religion supposedly required it. These hypotheticals forced a tough question. When personal beliefs collide with other people's rights, how do we decide whose freedom prevails?
Okay. Well, let's suppose that I said my religion, let's suppose there's a public accommodations clause in my state constitution. There is, and we have public accommodation statutes at the federal level. Let's suppose I said that my religion prohibits me from associating with people whose genetic makeup I don't approve, and they can't do business with my retail establishment. I'm trying to think of a status that is immutable. Where do you draw the line there? Can I do that?
Well, a state can always provide greater rights than are afforded in the federal Constitution.
Well, let me just cut to the chase. I'm sort of dancing around it. Let's suppose I took the position that my religion religion prohibits me from associating with people of color. Okay? And it's a sincere, it doesn't, by the way. I'm a Methodist. I was raised Presbyterian. My wife, when we got married, was Methodist, so we compromised. I became a Methodist. But let's suppose I belong to a religion that said I'm not supposed to worship with people of color. But under a public accommodations law, it says you have to let everybody come in. Where do you draw the line? And let's suppose mine is a sincerely held religious belief. I mean, I suppose I really believed it. I don't, of course, but I did. What's government's role here?
This is where things get complicated. As I explained, government has a dual responsibility. It must protect your sincerely held religious beliefs, but it also has to protect the constitutional rights of others. When those rights clash, the courts have to step in, often guided by precedent. This is the gray area, where justice is messy and compromise is unavoidable. Before I continue, if you're following along and want to stay updated on more breakdowns like this, make sure to hit that subscribe button and turn on notifications. Then Kennedy turned the conversation toward one of the most divisive issues in America: abortion. He asked directly, where has the Supreme Court drawn the line? The current test, as I explained, comes from Planned Parenthood v. Casey, which held that the government cannot impose an undue burden on a woman's right to seek an abortion.
Yeah, I mean, we're starting to see it a lot in terms of abortion. Mm-hmm. You know, I don't believe in abortion. Some people do. I believe that that's a human being. Other people believe that it's just a fetus. And it takes on religious connotations. Obviously, the government has and probably will continue to set rules about abortion. Where do you draw the line there?
Well, again, I recognize that's a very important issue. It's a very serious issue to
But
lots of people.
where do you think what I'm asking is, where do you think, and then I'm going to shut up, Mr. Chairman, where do you think the Supreme Court has drawn the line? What's the test?
Well, I think right now the test is generally that the government cannot impose an undue burden on a woman's right to seek an abortion. That was the decision in Casey. So I think that generally sets forth the test. But of course, I recognize there are a lot of differences of opinion about where that can be done and where it can't be done and what undue burden consists of. So that's a scenario where I'd have to look at whatever precedent's out there and try and figure out what the right result is.
But defining undue burden is exactly where battles are fought, both in the courts and in the culture. What Kennedy was really exposing is the balancing act judges are asked to perform every single day. It's not about personal belief or even political leaning. It's about precedent, constitutional protections, and the constant tension between individual rights and the public good. These are the moments that reveal just how heavy the responsibility of a judge truly is. So there you have it, a window into one of the most challenging discussions in American law, brought to life through Senator Kennedy's questioning. Issues of faith, freedom, and justice will always be complicated, but it's in these debates that the boundaries of our rights are defined. Thanks for watching, and I'll see you in the next breakdown.